Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law number 2 of Jefferson County, Texas. You have been asked to come here this morning because you have a case in this court. The case that you have is a criminal case. Criminal cases are divided into felonies or misdemeanors. The case that you have in this court is a misdemeanor case. Now, felony cases are normally referred to as your more serious type of offense. Your misdemeanor cases are normally referred as your petty offense. It does not mean that they're not serious. It just means that they are not as serious as a felony offense. And what I mean by serious, I'm not only talking about the actual crime, but I'm also talking about the punishment. Now, if you had a felony case, your felony cases are divided into 5 categories. There's the capital murder, first-degree felony, second-degree felony, third-degree felony, and the state jail felony. If you're convicted of a state jail felony, the range of punishment is anywhere from 6 months to 2 years in the state jail and a fine up to $10,000. If you're convicted of a third-degree felony, the range of punishment is a minimum of 2 years to a maximum of 10 years in the state penitentiary and a fine up to $10,000. Or if you're convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years in the state penitentiary, and a fine up to $10,000. Or if you're convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life, and a fine up to $10,000. Now, if you're convicted of a capital murder, which is the highest felony, the range of punishment is either life in the state penitentiary or death by lethal injection. Now, the case that you have in this court, as I mentioned earlier, is not a felony case, so you don't have to worry about going to the state penitentiary or being sent to state jail. Now, if you have a felony, if you have a misdemeanor case, the misdemeanor cases are divided into 3 categories. There's the Class A misdemeanor, Class B misdemeanor, and the Class C misdemeanor. The Class C misdemeanor offense, there are cases that are normally handled in the Justice of the Peace Court or the JP Court or the City Court, which is the municipal court. With a Class C misdemeanor, if you are convicted, the range of punishment is by fine only. You only can be given a fine. However, if you do not pay the fine, then they can issue what is called a capias pro fine, which is a warrant for your arrest to have you set out the fine if you do not pay it. Now, the Class B misdemeanor, the range of punishment is a minimum of 0 days to a maximum of 180 days in the county jail, a fine from $0 to $2,000, or you could be given both such fine and confinement. If you're convicted of a Class A misdemeanor, the range of punishment is a minimum of 0 days to a maximum of 365 days, which is 1 year in the county jail, a fine from $0 to $4,000, or you could be given both such fine and confinement. As a defendant in a criminal case, you have rights. One of the rights that you have, and is contained in the paperwork that is on the clipboard that has been handed out to you, you have a right to have an attorney. On the document that is titled Judge's Explanation of Rights to Defendants Without Attorney, it states, as a defendant in a criminal case, you have 3 options that is concerning your right to have an attorney. Number 1, you may hire an attorney. Number 2, if you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. Or number 3, if you want to represent yourself, or if you want to waive your right to have an attorney and represent yourself, you have a right to represent yourself. That's the 3rd option. Now, if you want an attorney to represent you and you have enough money to hire an attorney, the case will be reset. Reset means you'll be given another court date from this date. The case will be reset to give you time to hire your attorney. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire. The financial questionnaire is on that tablet, and it states Jefferson County Affidavit of Indigence. Now, you would have to fill out that financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. If you want to waive your right to an attorney, which means give up your right to have an attorney to represent you, and you desire to represent yourself, then you may not speak to the prosecutor about your case. Now, the prosecutor is the attorney that works for the district attorney's office. We call them assistant district attorney, or we call them a prosecutor. You cannot speak to the prosecutor about your case unless you sign a written waiver, which means you're waiving your right to have an attorney. Unless you sign a written waiver of your right to be represented by an attorney. Now, be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including a loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, if you choose to proceed without an attorney, you may change your mind at any time and may request counsel or request an attorney from the court. At the bottom of that document, it states, defendant's rights. Mark initials next to only one choice. Now, at the bottom of that document, if your choice is, I want to reset my case to hire an attorney, then you'll put your initials on the first line to the left. If you have already hired an attorney to represent you in your case, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is, I want to ask for a court-appointed attorney, then you will put your initials on the third line to the left. If you've already been appointed a court-appointed attorney, then you will place your initials on the fourth line to the left and the name of the attorney on the line to the right. If your choice is, I want to waive my right to have an attorney represent myself, then you will put your initials on the fifth line to the left. Now, once you have finished initialing one of the 5 lines, then you will sign your signature on the line below that is titled Defendant. And you will sign today's date on the line that is titled Date. And today's date is April 18th of 2023. Now, for those of you who will be waiving your right to have an attorney, that is, you want to represent yourself, you would have to read and sign the second form that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. And it reads as follows. I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised this 18th day of April of 2023 by County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I'm unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed to me free of charge if I'm not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. Now, if that is your decision, then you will sign on the line that is titled Defendant, and you will date it today's date, April 18th, 2023. Now, as a defendant in a criminal case, you also have additional rights. One other right that you have is you have a right to have what we call a jury trial. Where those young people are sitting in that area over there, that area is called the jury box. 6 citizens from Jefferson County will be selected on your case, and they will decide whether or not, after they listen to all of the evidence, they will decide whether or not you're guilty or you are not guilty of your charges. You also have a right to waive or give up your right to have a jury trial. What that means is you have a right not to have a jury trial if you so choose. Now, if you decide not to have a jury trial, then your case will come before the judge in one of 3 ways. One way it can come before the judge is by way of a trial. It's a trial by judge only, without a jury. We call that a bench trial. Now, you can waive your right to have a bench trial as well. If you decide to waive your right to have a bench trial, then one other way that your case will come before the judge is by way of an agreed plea bargain. An agreed plea bargain basically means that you and the state have reached an agreement to settle your case. And then you want your case to come before the judge, and the judge has the option to go along with the settlement or plea bargain agreement or not go along with it. He could accept it or reject it. Now, if the judge rejects your plea bargain agreement, at that point, you can withdraw or take back the agreement that you have made with the state. For example, the state and you have reached a plea bargain agreement, let's say for 1 day in jail, and the court, it comes before the court and the judge says, I'm not going to go along with that plea bargain agreement, then you could tell the judge, well, I withdraw or I take back my agreement. In essence, since you're not going along with it, I'm not going to enter a plea of guilty or no contest in this case to those charges. Now, your case can also come before the judge by way of an unagreed plea bargain agreement. What that means is you and the state, you and the prosecutor have not been able to reach an agreement to settle your case, but you want the judge to assess the punishment. Now, once the case comes before the court, then the judge will have the option to assess what the punishment will be in your case. Now, at that point, that's unagreed, so you can't withdraw your plea. You can't, if the judge say 50 days in jail or something like that, you can't say, well, judge, I withdraw my agreement. Well, you can't do that on an unagreed plea bargain agreement, okay? Now, as a defendant in a criminal case, you also have a right to have witnesses to come to court. What witnesses do, they can testify from that chair over there. We call that the witness stand. They can testify for you or against you if you represent yourself or if you're represented by an attorney. You can ask them questions if you're representing yourself, or if you have an attorney, the attorney can ask them questions. We call that either direct examination or cross-examination. Now, you can waive or give up your right to have witnesses to come to court. That simply means that you will not be calling witnesses in your case. It does not mean that the state will not be calling witnesses, because the state will be calling witnesses because they're the ones who have filed the charges against you. You also have a Fifth Amendment right against self-incrimination. What that means is you have a right not to testify against yourself in your case. In essence, you have a right not to testify in your case. The district attorney's office or the state cannot force you to testify. They can't call you as a witness because you have a Fifth Amendment right against self-incrimination. Now, however, if you waive or give up your Fifth Amendment right against self-incrimination, that simply means that you will be testifying in your case. As a defendant in a criminal case, you have a right to see the evidence. We call that, you have a right to have discovery. You have a right to see all of the evidence that the state has against you or that they will be using against you. You have a right to have access to that. If you're representing yourself, you will have access to it. Or if you have an attorney, your attorney will have access to it on your behalf, and he could share that with you, let you know what type of evidence they have. What I mean by evidence, it could be reports, videotapes, audio recordings, photos. It can be documents. It can be witness statements, objects that they may have. Whatever evidence that they have, you have a right, or your attorney would have a right to have access to that evidence so that you can prepare it for trial. Now, everyone that's here today, you should understand that there are 3 ways you can plead. You can enter a plea of not guilty. If you enter a plea of not guilty, you're telling the court that you did not commit the offense that you've been charged with. Or you can enter a plea of guilty. If you enter a plea of guilty, you're telling the court that you committed the offense that you have been charged with. Or you can enter a plea of no contest, which means you will not be fighting or you will not be contesting the charges against you. Now, each and every one of you have been arrested, you've been in jail, and you have bonded out. You're either out of jail on a cash bond, which means that you paid the full amount of cash to get out of jail. Or you're out on a surety bond, which means that you paid a bondsman to get on your bond, and you paid the bondsman a percentage of that bond to get out of jail. Or you're out of jail on what we call a PR bond, which means that you did not pay any money to get out of jail. PR means personal recognizance. You were released on your own personal recognizance, promising to appear in court. Now, every day that you spent in jail can be used as credit toward your punishment. For example, if you have spent 5 days in jail and you and the prosecutor have worked out an agreement to settle your case for 5 days in jail, that simply means that you will not have to spend any more time in jail. Why? Because you've already spent 5 days in jail. Therefore, you'll be given credit for the time that you have already served. If they are offering 7 days in jail and you only serve 5 days in jail, that means you will only have to serve 2 more days in jail on the sentence. Now, every day that you spent in jail can also be used as credit towards your fine and court costs. Every day that you spend in jail, you get credited $100 that will go toward your fine and court costs. So if we use that same example, you spent 5 days in jail, that's $500. The state is offering you a fine and court costs of $500. That means you won't have to pay anything. Why? Because this 5 days that you spent in jail has already paid it off. Therefore, the fine will be taxed and retired, which means that you will not have to pay it. However, if they offer a fine and court cost of $700 and you only spent 5 days in jail, that means you have to pay $200. Now, you'll be required to pay $200 on the day that you dispose of your case. If you cannot pay the fine on the day that you dispose of your case, then you'll be ordered to pay the fine and court costs in monthly installments, which means you could pay it off so much per month until it's paid off. Now, if you're unable to pay it off because you do not have the income, even if we allowed you to pay it off in monthly installments, you still won't be able to pay it off. Then we can convert your fine and court costs to community service. You will receive $12.50 that will go toward every hour that you perform in community service at a nonprofit organization. So for example, if you work, say 1 day, 8 hours at a nonprofit organization, get $12.50 an hour. $12.50 times 8 is $100. So you'll have $100 that will go towards your fine and court costs. Now, Jefferson County has a program that is called, Jefferson County has a program that is called pretrial diversion. That's for first-time offenders. What Jefferson County, when I'm talking about the DA's office, what they will do is dismiss your case, and you can get it removed from your criminal history. And the way it works is as follows. First of all, you have to have an attorney to assist you at writing the letter to get you into the program. Then it cannot be for an offense involving unlawfully carrying a weapon or resisting arrest. And as I mentioned earlier, it has to be your first offense. You cannot have a criminal history. Once you get into the program, they will dismiss your case. Once you complete the program, then you can get it expunged from your record, which means erase, remove, or delete it from your criminal history. If you are a veteran of any one of the branches of the United States military, they also have another program that is called Veterans Court, and it operates the same way as the other pretrial diversion. Basically, you get into the program as a veteran, you complete the program, you can get it expunged from your record. Okay, you get it erased, dismissed, and expunged from your criminal history. And as I mentioned earlier, expunged means erased, deleted, or wiped off from your criminal history. The next thing is this court, County Court at Law Number 2, has a program that is called the Community Safety Initiatives. We commonly refer to as the CSI program. With that program, the program is designed to address the issue of recidivism. Recidivism means that how people commit crimes over and over. And the way we address it is through partnerships that we have with local agencies in the community. One of the agencies that we have in the community, this partnership with, is Spindletop. The young people that you see sitting over there in the jury box, they're from Spindletop. They'll come to you a little later and talk to you about the program that they have to offer at Spindletop. Now, with the Spindletop program, Spindletop will do a private interview. They can they develop an assessment, and then they can develop a treatment plan to address whatever mental health needs that you have. The needs could be anxiety, depression, bipolar, schizophrenia, post-traumatic stress, there's a whole host of other mental illnesses that a person may have. They can address those on your behalf. The other thing is Spindletop also has a program that is called ATAR. ATAR stands for Addiction Treatment and Recovery. It is a drug treatment and an alcohol treatment or recovery program. Now, with ATAR, along with there's the local alcohol and drug council has a program called OZAR. OZAR is also a drug and alcohol treatment program. With those programs, they can do a screening, do an assessment, and then they can develop a treatment plan either for outpatient or inpatient. I know OZAR, you can be referred to outpatient or inpatient services. Spindletop have their own services also on their campus or on their site. If you are unemployed, do not have a job, or looking for a better job, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE, stand for the Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, or the chemical industry. Once you're trained in one of those areas, they will assist you at getting a job in the area that you're trained in. If you do not have a high school diploma, CICE also have a program for GED where you can get your graduate equivalency diploma. All of the programs that I just mentioned to you are free. It does not cost you anything. Only thing you have to do is have a desire to be in one of the programs. The other benefit about the program is all of these programs could be used as community service toward your punishment. So for example, let's say you had a fine to pay, but you didn't have the money to pay the fine. And then we converted the fine to community service. And every hour that you're in one of these programs, $12.50 will go for payment of your fine and court costs, and 1 hour will go toward the community service. And that's the same thing if you're working on your GED, or if you're in job training, or if you're in the program with Spindletop, or you in the alcohol or drug treatment program. While you there 1 hour, $12.50 will go toward your fine and court costs, and 1 hour will go toward community service. So you're doing one thing, but you're getting credit for three things. You're in the program, you're getting the fine and court costs paid, and then you're getting community service, all at one time. Now, if you're interested in the programs, just let the court know, and then we'll be happy to give you point you in the right direction with the brochures and phone numbers where you can make phone calls to get the services that you would like to get. Now, all of these programs that I mentioned are free, does not cost you anything. And these are programs that I started in March of 2017, within the first 100 days of taking office. And when you come to County Court at Law number 2, we do not just have court as usual. We have unusual court, and it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that comes before this court, and we're trying to make a difference in Jefferson County and the county in which we live by making Jefferson County a safer place for all of us to live, work, go to school, raise our children, and go to church. We do not just arrest the problem, we address the problem. We don't just give time, we take our time. And with these programs, we believe that we can produce productive people, and we believe that productive people would not commit crimes because they have too much to lose. So at this time, we're going to have Deputy Hinton and Kristen that's going to come forward from Spindletop, and they're going to give you some valuable information about the program that they have to offer at Spindletop. Deputy Hinton, Kristen.
Thank you, Your Honor. Good morning. My name is Steve Hinton. I am a mental health deputy licensed by the state, commissioned by the sheriff's office. My coworker, Chris. Chris is a well-educated, qualified mental health professional. The reason we are both here today is because the judge cares about every single person that comes before the bench. What the judge has found, that statistics prove, is those who have legal issues commonly have mental health, substance use disorders, or sometimes just a lack of community resources.
So whenever you said mental health, it means things like anxiety, depression, things that we all deal with in our day-to-day life, like being involved in substance use. Substance use can be a problem, tobacco, it doesn't have to be anything that looks bigger, it's just something that impacts the day-to-day life. We have a lot of community resources in the area, not just Jefferson County, but Texas and different, that are well funded, but they're not well advertised. So they're there, it's a little bit harder to get set up with, and if you're already having to juggle on other things, even adding in something that could help, may be overwhelming. That's where we come in. We are here to help you with whatever you need. The form that you filled out, or that I got when you came in, functions as a baseline for the consent form. What that means is that information on it is protected under state law. It is private. It will not be shared without your permission. The only thing that allows me to do is call the next you once or talk to you privately if you select it on. We will not give your number out to anybody. We will not sit there and call you constantly. But the important thing is that you have the ability to reach out to us, and we have the ability to reach out to you. Doing it is hard for you, as you work for yourself, and you work hard to set up for you. We know you work hard for yourself.
Now, maybe this is your first time to be here, maybe it's the 10th time to be here, there's still hope. That the document that she handed out when y'all came in, that is information we're gonna use to best serve you with whatever situation you may be going through. Also, there's a flyer here that tells you a little bit about the program. I want to get this in everyone's hands, but it tells you some of the advantages of it as well. But also, there's a 1-800 number on here. Should you ever find yourself in an unsafe place, you can call that number and get help immediately.
Now, what's important about that 1-800 number is, again, this is statewide, right? We know that a lot of people end up in Fort Jackson County who may not necessarily be from this area. That 1-800 number covers about 80% of Texas. So that's a good tool to keep with you in your car if something ever happens, if you're having, if something stressful is happening and you're on the side of the road, and you can't talk to someone. You can call that number and they will either work you through or they will get you set up with the most outdoor resource in your area.
So to best serve you on that document, either today, we can talk to you privately, but we're gonna need you to share that need with us so that we can best serve you in whatever particular situation, again, that you may find yourself into and maybe need help with. Again, it's private. We're not gonna share this outside of your budget. We do have, permission to, talk privately in a room in the back if you want to do that today. If not, we will call or text you, whatever you desire, and put on that document. We will not.
Now, we do have interns who work with Lamar. If there is a specific resource you know you need, or you know somebody in your family or your friends need, let us know, write it down, because we have people who are willing to look and find those. And they will find something that is either state funded, grant funded, or a sliding fee scale. So the financial stress is not something we add on to this. But if you let us know, we will work with you to get that fixed.
And just a little bit, the court's gonna go into recess. When they do, we will come out and visit with you and pick up those documents from you, and I'll hand everyone one of these as well.
Thank you for your time.
Thank you, Your Honor.
You're welcome. Now, ladies and gentlemen, the information that has been handed out to you, if you need some assistance in filling out the paperwork, we have our court personnel here who will be happy to assist you. It's going to take a few minutes for each and every one of you to fill out the paperwork, and then we're going to have to pick up that paperwork, and then we're going to call you before the bench one at a time. That's going to take a little time because we have to put them in various different categories. Now, if any one of you need to use the restroom, we have restrooms right outside the door, right across from County Court at Law Number 3, which is right next door to us. That's the men's restroom. And then across the hall, right in front of the 172nd District Court, there's a female restroom right in front of that courtroom. So if you need to use the restroom, you can go use the restrooms. And if you need any assistance, just please raise your hand and we'll have someone from our court personnel who will be happy to assist you. Okay, so at this time, the court will be in recess, and